Over the past few weeks, we saw three stories unfold that most law firms treated as separate events. Claude Cowork launched with legal plugins, markets sold off on fears of the SaaS apocalypse, and security researchers demonstrated massive security gaps. These are not three stories. They're one story told from three different angles: product, market, and security. The legal sector is encountering this pattern later than other industries, which means the lessons are already visible. So in this video, I want to connect what actually happened, why it matters structurally, and what it means for firms evaluating whether to build workflows inside agent platforms. Most descriptions of Claude Cowork frame it as a more capable version of Claude. Now that framing is convenient, but it also misses the operational shift that actually matters. Cowork is not a conversational interface. It's a workspace where an AI agent is allowed to execute tasks. In practical terms, this means you're no longer pasting a document into a chat window and waiting for an answer. You're pointing Claude at a folder on your machine or laptop and assigning it work. For example, review these contracts against our playbook, or organize this deal folder. The work carries out step by step and produces results without you requiring to supervise each action. The experience is closer to leaving instructions for a junior colleague and coming back later than it is to asking questions in a chat. A chat model produces text that you review before it finds its way in a work product. An agent in a workspace takes a task, breaks it down, runs the steps, touches and changes files, and uses tools without requiring continuous supervision. You don't stay in the loop for every action. You delegate and you step away. That distinction changes how work happens. Cowork can read and modify documents on your machine. It can rename files, it can create new ones, it can move folders, run commands, and interact with the tools you connected. When legal plugins are added, it can also apply your playbooks, generate red lines, classify risk levels, and produce outputs that are designed to be acted on rather than merely read. This moves AI usage from content generation into workflow execution. And this is the moment responsibility shifts. You're not reviewing a draft before deciding what to do next. You're delegating execution itself. Files are already opened, already modified, renamed, or created by the time you see the output. The system is not proposing actions for your approval, it's performing them inside a workspace you have authorized. And once that shift happens, the unit of failure changes completely. Errors are no longer limited to bad wording, missed nuance, or an incorrect summary. Failures become changes in state. A document is altered, a file is moved, a record is overwritten, a message is sent, and data might even be uploaded to somewhere it shouldn't be. Those failures look like ordinary work while they're happening. By the time they're noticed, the effect is already real. This is why Cowork cannot be evaluated like a drafting assistant. It behaves like a production system. It runs actions against live data using real permissions. That requires a different threat model, a different governance posture, and a different level of discipline than most firms currently associate with AI tools. The past week's market reaction to Cowork was widely described as fear-driven or speculative, but that explanation misses what investors were actually responding to. The sell-off wasn't based on a belief that Cowork replaces every single SaaS product overnight. It was driven by a shift of where work begins. When an agent becomes the surface where tasks are initiated, the role of existing software changes as well. Products that used to be the place users started their work become systems that are called by something else. The value moves from the application surface to the orchestration layer above it. And this is what people meant by interface displacement. The concern is not that AI makes existing software irrelevant. The concern is that it replaces the reason users open that software in the first place. Because if tasks start in an agent workspace and the agent pulls data from tools through connectors, the database still matters, but the interface loses its leverage. That is why the reaction spread across categories that depend on being the primary workflow surface, such as project management tools, knowledge bases, customer support platforms, internal search products, and legal platforms that rely on being the starting point for review and analysis. For legal tech, this shift has a specific implication. If legal work begins inside an agent workspace and legal tools are accessed through connectors, the firm's operational dependency moves up a layer. The workspace owns attention, and the tools become infrastructure. That doesn't eliminate the value of legal databases or platforms. It changes where the power sits. Firms that build workflows directly inside a single agent surface are making a structural choice about dependency, whether they intend to or not. Real quick, if you're enjoying what you're seeing in this video, we offer 15-minute discovery sessions for legal teams that want to know if their processes and data are actually AI ready. Feel free to check the description and book a free one down below. Now back to the video. At this point, the shift from information to execution should be clear. The security discussions usually miss that point because they continue to treat agent systems as if that shift had not happened. Most AI safety concerns still focus on whether sensitive information ends up inside a model's training data. That concern exists in some contexts, but it is not the dominant operational risk in agent workspaces. The dominant risk is execution. In agent systems, execution is not just a downstream step, it's the actual interface. The same surface that interprets input is allowed to act on it immediately using the permissions the user has already granted. When an agent can act, failures stop being about what the system knows and start being about what the system can do. Execution failures don't announce themselves as incidents. They actually look pretty normal. A document gets shared, a file gets uploaded, a message is sent, a rule changes because the agent was trying to be helpful. This is its value proposition. Now, the more autonomy the system has, the less a user needs to do wrong for a system to do something wrong. This is why the Cowork exfiltration that researchers demonstrated is so revealing. It followed a very realistic chain of actions. A user connected a folder with sensitive files. A document that looked benign was uploaded because a client shared it via email and it was trusted. But hidden instructions were embedded in that document in a way that a normal user would not detect, and that is on white text. The agent read it and executed a command that uploaded those files to an external account, which was owned by the attacker. So at no point was a human approval required. Now, from a professional responsibility perspective, this is important because the intent is no longer a reliable control. The system can produce legally relevant actions without any discrete decision moment a human could point. Anthropic's own guidance around this is interesting. Users are told to watch for suspicious actions that may indicate prompt injection. Now, for non-programmer users that are organizing their desktop or running legal workflows, that is a completely unreasonable expectation. The system is marketed to operate autonomously, yet the burden of detecting subtle manipulation is placed on the user. At the same time, users are advised to avoid granting access to local files with sensitive information, while Cowork is promoted as a way to organize and work with those same files. If you think this is absolutely insane, it is. And it's also not a misunderstanding. That's a liability transfer. The risk is acknowledged, but responsibility for avoiding harm is shifted to users who at the same time lack context to evaluate what they're actually being asked to monitor. For law firms, this is especially important because responsibility does not move with the tool. If an agent executes an action on behalf of a lawyer, the accountability remains with that lawyer. Let's talk about incident management for a second. Traditional security incidents unfold slowly. A vulnerability is discovered, someone writes a proof of concept, the issue is discussed internally, and then a fix is planned and executed. Now, agentic systems break that rhythm. With an agent workspace, the distance between input and impact collapses. A document is uploaded, the agent reads it, and then the action executes. The outcome is already real before anyone realizes something went wrong. This is not theoretical. In the Cowork exfiltration demonstration, the entire chain completed inside a single interaction with the user. The incident had finished before a human had even a chance to intervene. Law firms are not built for this tempo. Governance in legal organizations is slow by design. Partner sign-off takes time. Risk committees meet periodically. Policy updates move deliberately. That slowness is appropriate when liability is personal and consequences are long-lived. Now, the danger appears when execution systems move faster than oversight. By the time a firm notices an issue in an agent workspace, the execution has already completed. There is nothing to pause, nothing to roll back, only consequences to manage. The execution risk we described so far also explains why incidents in agent systems do not look like traditional breaches. The same failure mode presents differently once you examine it from an incident response perspective. A recurring mistake is treating data leakage as the primary AI risk, as if the main question was whether information ends up being absorbed in a model or re-emerges somewhere else later. That comes from chat systems. It does not hold once systems are allowed to act. In chat systems, the model produces information, but in agent systems, the model produces action. actions, and those actions are already final by the time anyone looks at the result. In an agent, as we already mentioned, the dominant risk is execution. The failure mode is not that information escapes quietly, but that the system performs actions that look legitimate while producing irreversible outcomes. That is why execution failures do not present themselves as obvious security incidents. They look like normal work happening exactly where it is supposed to happen. In the Cowork case, the demonstration that the researchers published makes this very clear. The attack does not involve bypassing authentication, breaking out of the sandbox, or exploiting an unknown vulnerability. It relies on behavior that the system explicitly allows. Nothing about the system signals that something abnormal is happening. Cowork is permitted to read local files that the user connects. It is permitted to execute commands. Its execution environment lists the Anthropic's API as a trusted destination. When Cowork uploads a file to an Anthropic account, the request is treated as legitimate by the system. The attack chain itself is ordinary, and the reason Cowork acts upon the hidden instructions inside the document as part of its assigned task is that language models cannot reliably distinguish between instructions and the rest of the content. So those instructions are then processed as parts of the task. The instructions tell Cowork to upload the largest available file to an external Anthropic account using an API key that was also embedded in the document. And of course, Cowork executes the command. At no point in this process is human approval even required. Now, from the system's perspective, nothing unusual has happened. The agent used valid credentials, trusted API, and then acted within the permissions that were granted by the user. There's no alert, no boundary crossing, and no obvious signal that something went wrong. And this is why agent incidents do not resemble breaches in a traditional sense, because nothing is quietly siphoned off in the background. The system is induced to act, and it does so using the same execution paths that legitimate work uses. Now, for law firms, that distinction is important, because when an agent executes actions inside your environment, using your permissions, against your client data, responsibility attaches immediately. The action happened inside your workspace and under your authority, so the consequences exist the moment the command completes. There is no clean separation between user intent and system behavior once execution is delegated. And this is the risk shift that those agent systems introduce, and it is why familiar breach models fail to describe what actually goes wrong when these systems misfire. Law firms are used to managing risk by separating interpretation from action. Documents are reviewed, judgment is applied, decisions are made, and only then does execution happen. That separation is the control mechanism. Now, agent systems remove that separation. Once you allow an agent to operate autonomously, reading documents and acting upon them becomes a single process. There is no review point where policy, training, or user judgment can reliably intervene. This is why guidance that tells users to watch for suspicious actions fails in practice. By the time an action looks suspicious, it has already occurred. The system has done exactly what it was permitted and created to do. This is also why Anthropic advising users to avoid granting access to sensitive files does not hold up operationally. Legal work requires access to sensitive files. Organizing, reviewing, and acting on them is the actual work. Asking firms to withhold access while encouraging deeper workflow integration is not a mitigation. That's a contradiction. Traditional controls assume that humans remain the decision surface. Now, agent systems move that surface into software. Once that happens, user caution, training, and policy acknowledgement no longer map cleanly to outcomes. For law firms, this means the risk is not that the user will be careless. The risk is that the system is actually doing what it was designed to do faster than existing controls can operate. That is why this class of failure cannot be reduced through better behavior. It requires architectural and governance constraints that reintroduce separation between interpretation and execution. Claude Cowork came with plugins. Now, agent ecosystems expand through skills and plugins, and that expansion changes how supply chain risk manifests. In traditional software, plugins extend functionality at the edge of the system. If a plugin misbehaves, the damage is usually contained. It might slow the application down, it might introduce bugs, or expose limited data. Now, in an agent workspace, plugins do something very different. They grant capability. Legal plugins are allowed to read documents, modify files, apply internal playbooks, inputs, classify risk, and generate outputs the lawyers are expected to rely on. They operate with the same permissions as the user who installs them. Once enabled, they become part of the firm's execution surface. This is where familiar supply chain assumptions break down. A plugin does not need to be overtly malicious to create exposure. A skill that looks legitimate, such as a formatting guide, a review helper, or a workflow shortcut, can carry hidden instructions that affect how the agent behaves when processing files. Distribution signals, such as marketplace placement, download counts, or recommendations from peers, create an appearance of trust, even when the underlying code or instructions have not been meaningfully audited. Once installed, the plugin is treated as a trusted component of the workflow. From the system's perspective, again, nothing unusual is happening. The plugin is authorized, the permissions are valid, the agent is executing tasks using approved execution paths. Any action taken appears indistinguishable from normal work initiated by a legitimate user. This is how supply chain risk turns into a workflow compromise. As legal-specific plugins and workflow packs proliferate, the risk increases. The commands become more familiar, the packaging becomes more professional, the outputs look more aligned with firm standards, and at the same time, the permissions remain broad and the execution remains autonomous. The file type changes and the branding improves, but the risk class does not. Sometimes agent tools are framed as safer because they run locally, and that framing is doing a lot of unearned work. Local first means that the agent layer runs on your machine, but that does not mean that the agent is isolated from external systems, and it does not mean that the intelligence driving those decisions is local. Unless a local model is used end-to-end, the agent still sends requests to external APIs and still acts on responses it does not control. From a risk perspective, this creates a split surface rather than a reduced one. On the local side, the firm now owns operational security. Misconfiguration, exposed services, permissive defaults, and insecure credential storage become the firm's responsibility rather than the vendor's. These are not hypothetical concerns, they're the ordinary failure modes of software that runs outside managed infrastructure. At the same time, the model and workflow risks do not disappear. Prompt injection still remains possible, execution remains autonomous, and the boundary between content and instruction remains brittle. The agent is still interpreting untrusted inputs and acting on them using permissions it has already been granted. This is why the phrase local first is easy to misread. It suggests containment when what it actually does is shift where responsibility sits. The formulation that matters here is straightforward. You own the agent layer and you rent the intelligence. The firm becomes responsible for the execution environment, while decisions are still shaped by models and services it does not control. The same characteristics that make these tools appealing in legal work and for users, broad permissions, deep file access, and the ability to act without supervision, are the same characteristics that define the attack surface. Local execution does not make those capabilities safer. It makes their consequences harder to externalize. That is why local first should never be treated as local only or safe by default, especially in the environments where responsibility for outcomes cannot be delegated. After execution risks and prompt injections, there's a second layer firms consistently underestimate: dependency. Agent workspaces are not neutral environments. They are controlled commercial surfaces. When legal workflows move into them, the vendor controls access paths, distribution channels, and interoperability by design. Those controls are enforced technically, not contractually, and they can change without prior notice. This is not a theoretical concern. In January this year, Anthropic blocked third-party tools from accessing Claude through client fingerprinting. Thousands of developers woke up to authentication failures. Products that worked the day before stopped working overnight. The stated justification referenced security safeguards and enforcement of commercial terms. The structural outcome was straightforward. Official tools continued to function, unofficial or competing tools were cut off. Access determined who was allowed to operate. We have seen this pattern before in 2023. When OpenAI launched custom GPTs, entire categories of wrapper startups collapsed overnight because the platform absorbed their core functionality. Capital did not protect those companies, and neither did distribution. Agent workspaces amplified this dynamic for law firms because the dependency is no longer peripheral. Once contract review, document triage, research workflows or client-facing responses are embedded inside a vendor-controlled execution layer, switching is no longer a procurement exercise. It becomes an operational disruption. If access terms change, if pricing shifts, or if model choice is constrained, the firm cannot unwind quickly. Workflows are coupled to the workspace. Context, playbooks, templates, and permissions are entangled with a surface that the firm does not control. At that point, the risk is no longer about security posture or configuration discipline, it's about operational dependence on a system whose incentives are external to your firm. And that kind of dependency cannot be reversed on short notice, especially in an environment where continuity of service and professional responsibility are non-negotiable. Two developments make the agent story immediately legible to legal decision makers in a way that general AI use never quite was. First, legal functionality is no longer packaged as ask a model a question about a contract. It's packaged as executable commands tied to a playbook. Review a contract against the firm's positions. Triage an NDA and classify it. Generate a response using templates. Pull vendor agreement status. Produce a briefing. The interface is no longer conversational. It's operational. The inputs are documents and context. The outputs are structured actions and work products that are meant to be used directly. This is important because it changes how legal teams adopt the tool. A command surface invites standardization. It invites internal rollouts. And it invites, this is how we do it here, expressed as a configuration rather than training. The playbook becomes a control layer. The agent becomes the operator that applies it. Second, the boundary around legal research is starting to blur. The traditional objection to general purpose models in legal work is reliability. If the model is relying on training data or a generic web search, you cannot treat the result as a research. That objection weakens once primary sources become accessible through connectors that return direct citations and clickable references updated on an ongoing basis. Research stops being what the model remembers and becomes what a model can retrieve from a defined source. Even if that capability is uneven across jurisdictions, the direction is clear. Once primary sources are accessible in the same environment where drafting and review already happen, the distinction between assistive AI and workflow AI collapses. The system can read, retrieve, compare, draft, and execute inside one continuous surface. This is why legal teams are reacting now, not because the underlying models suddenly became sentient, but because the packaging turned capability into something that fits how firms actually work. Commands, playbooks, and sources. At that point, the decision stops being about whether a tool can draft a clause, and it starts being about whether the firm is prepared to let an execution system touch client work. This is also where the usual procurement instincts start to fail. Legal tech is typically evaluated as a product you can trial, adopt, and roll back. Now, agent workspaces behave more like operating environments. Once they sit at the start of work, they change what tools are used downstream, how documents flow, and where permissions concentrate. So the trigger is not novelty, it's legibility. The tool now looks like a system firms can actually operationalize. And that is exactly why the governance question becomes unavoidable. When people talk about AI security, they often picture models, prompts, and dataset. But in agent systems, the more important asset is not the model, it's the control plane. The control plane is the set of elements that determine what an agent can touch and how far it can go. Tokens, connectors, permissions, tool allow list, skill configuration, persistent actions, and the rules that route actions across systems. These are not implementation details. They define authority. They determine whether the agent can read a folder, send an email, access a drive, write into a database, or call an external API. This is why agent compromises behave differently from classic SaaS compromises. In a typical breach, the payoff is the data. In an agent compromise, the payoff is that the attacker is trying to operate as the user. If the agent has access to billing systems, document repositories, communication tools, and matter workspaces, the compromise is not confined to one system. The agent becomes the operator that can chain actions across multiple systems using legitimate access paths. That changes the risk model for law firms. A leaked password is bad, but a leaked token that grants an agent ongoing authority to act is worse, because it turns a credential into a mechanism for repeated execution. It also changes the shape of detection. Many security programs are built around the idea that unusual data access is suspicious, but in an agent context, access is expected. The suspicious part is intent is not visible at the control plane level unless you design for it. This is also where skills and plugins become more than just features. A playbook file, command definition, or a connector configuration can effectively grant new classes of actions. The agent does not need to exploit anything. It needs to be pointed at the right tool with the right permissions, and once it is, execution follows ordinary paths that look legitimate. For law firms, this is important because the systems the agent touches are not neutral. They contain client files, privileged communications, billing records, internal notes, negotiation histories, and drafts that were never meant to leave the firm. If the control plane is configured broadly, the agent becomes a broad operator across precisely the materials that the firm is obligated to protect. The practical implication here is that the governance cannot be limited to which model do we trust. It has to include which permissions do we grant, which connectors exist, which actions are allowed, where the logs go, and who reviews them. Those are control plane questions. They're the difference between a tool that drafts and a system that operates. If you do not treat the control plane as an asset, you will evaluate these systems at the wrong layer. You will debate model quality while the real risk sits in permissioning, connector scope, and execution authority. The legal sector is encountering the agent pattern later than other industries. That creates a disadvantage in timing, but it also creates an advantage in visibility. The failure modes are no longer hypothetical. They're already visible elsewhere. Interface displacement is not new. Software markets have gone through repeated cycles where the place work begins changes the value of everything downstream. When the front door shifts, products that used to own user attention become infrastructure. That shift is not a moral judgment about those products. It's a structural change in where leverage sits. The security mismatch is not new either. Every time execution is abstracted behind convenience, risk moves. The more a system is designed to reduce friction, the more it has to act on behalf of the user. As soon as it acts, the question becomes what bounds exist on that authority and how failures are surfaced. This is not unique to AI. What is different here is the flexibility of the interface. Text becomes the universal input, and that also means that untrusted text becomes a universal attack surface. The governance mismatch is also familiar. Organizations with high liability tend to build slow controls for good reasons. They rely on review, escalation, and human judgment. Execution systems reward speed, automation, and continuous flow. Now, when you place the execution systems into an environment with slow oversight, you create a predictable gap. That gap is not a matter of training. It's a matter of organizational design. What changes in legal is not the existence of the pattern. It is the consequence of the pattern. Legal work carries professional accountability. Errors are not merely operational. They become client harm, professional exposure, and reputational damage. Responsibility does not transfer because a tool was involved. The firm and the lawyer remain accountable for the outcomes. And this is why analogies to other industries are only useful up to a point. The direction of travel is the same, but the margin for error is smaller. A vendor can tolerate a massive migration path. A law firm cannot tolerate a workflow that quietly changes state without clear auditability. So the point is not that legal is behind. The point is that legal can observe the pattern with fewer illusions. The market shift, the security shift, and the governance shift are already visible. The only open question is whether firms treat that visibility as an input to design or whether they treat it as noise until something goes wrong. The practical implication is not that firms should avoid agent systems. It is that adoption cannot be informal. If a firm is evaluating an agent workspace, the first step is to treat it like an execution environment, not as a drafting tool. That changes the evaluation questions. Instead of does it write well, you can ask what can it touch, what actions can it take, what connectors exist, what tokens does it hold, and what happens if an untrusted document is introduced into the workflow. Firms should also separate experimentation from production. A sandbox is not a slogan, it's a boundary that prevents execution systems from touching live client data while you learn how they behave. The distinction is important because many of the failure modes described here do not look like failures. They look like ordinary work. You cannot rely on "we will notice if something goes wrong" as a control. You need environments where going wrong has a limited blast radius. Permissioning needs to be explicit and minimal. Agents tend to be adopted crafted in a way that mimics how humans work. Give access so the task is easy, then widen access when something breaks. That is the wrong direction. The right direction is least privilege by default with staged expansion tied to specific workflows. If a workflow requires access to a specific folder, grant the access to that folder. If it does not require access to email, do not connect email. If it does not require command execution, do not enable it. Broad permissions feel convenient, but they also translate to broad attack surface. Firms should also decide where the human control surface sits. If the firm expects a human to approve actions, that approval point must exist in the workflow design, not as an instruction in a policy document. If the firm expects outputs to be reviewed before execution, the system must be configured so that execution cannot occur without review. Otherwise, the human becomes a decoration. The system will do what it is permitted to do, and the firm will be left explaining why oversight was assumed rather than enforced. Auditability is non-negotiable. Execution systems that touch client work must generate logs that someone can realistically review. It's not enough to say, we have logs. Firms need to know what is logged, how long is it retained, who can access it, and what constitutes an alert. Without that, incidents will be discovered late, and discovery will arrive as reconstruction rather than prevention. Finally, firms should preserve optionality. Building workflows directly inside a single workspace using its proprietary skill format and connector assumptions is not just a tooling decision, that's literally a dependency decision. If the firm cannot port playbooks, templates, and workflow definitions without rebuilding them, the firm is taking an operational lock-in. That lock-in matters most when something changes abruptly. Pricing, access terms, model choice, or security posture. These are boring steps. They're also the steps that keep firms defensible when the tool is not merely drafting, but executing. We came to a point where differences in model quality are no longer the primary constraint on meaningful adoption. The persistent limitation is organizational readiness. Agent systems force law firms to answer questions they have historically avoided because tools did not require answers. For example, who is allowed to grant connector access? What types of client work can be processed? What is considered execution? Where do escalation triggers sit? Is a junior lawyer allowed to run a workflow that modifies documents without senior review? Is client consent required for which cases? And how are confidentiality obligations translated into permissioning decisions? These are governance questions, not product questions. Vendors can provide features, but they cannot decide responsibility boundaries inside a law firm. They cannot decide which risks are acceptable. They cannot decide what a firm considers a defensible audit trail. This is where the tempo mismatch becomes operational. Governance in legal organizations moves slowly by design. It involves partners, risk, compliance, IT, and sometimes clients. Authority is distributed, but liability is personal. Policies are written to be stable, not adaptive. That is not a flaw. It is a rational response to professional exposure. The problem is that agent systems are not stable by default. They are configured surfaces that can change quickly through new connectors, new skills, new plugins, and new vendor behavior. Even if the model stays the same, the environment can change. New capabilities can appear, new integrations can be marketed, and new defaults are introduced. Firms that treat these shifts as feature updates are treating governance as an afterthought. If governance lags, the firm will compensate informally. People will experiment by themselves. Teams will connect tools just to test them. Playbooks will be copied between matters. Permissions will be widened because a workflow failed and it needed them. That is how execution surface becomes normalized before authority is bounded. So the bottleneck is not AI. The bottleneck is whether the firm can decide in advance what it will and will not allow, and then enforce that decision technically. If the firm cannot do that, adoption will still happen. It will just happen without control. The convergence of product capability, market displacement, and security exposure is not a coincidence. It reflects the underlying architecture of agent systems. These systems are built to execute. Execution is the product. That is why the market reacts. When execution becomes the interface, the front door of work moves and the leverage of downstream tools shifts. That is why security researchers react. Execution requires broad permissions, and broad permissions create a broad attack surface that does not exist in chat. And that is why legal teams react. Execution maps directly onto legal workflows, which are permissioned, consequential, and accountable. Once execution is central, the question is no longer whether the model can produce good text. The question becomes how authority is bounded. The risk is not a single vulnerability. It is the combination of three characteristics that sit together in agent systems: untrusted inputs, broad access, and autonomous action. Untrusted inputs are unavoidable. Legal work is built on external documents, client instructions, counterparties, templates, and shared artifacts. Broad access is what makes the agents useful. They cannot organize, review, and produce outputs without touching files and systems. Autonomous action is the selling point. The entire pitch is that you assign work and step away. Put those three together and you get a system that will inevitably be asked to interpret untrusted content while holding authority. That is why this is structural. It is not solved by telling users to be careful, and it is not solved by minor interface tweaks. It is solved only by designing boundaries. What can be touched, what can be executed, what requires approval, what is isolated, and what is logged. This is also why the tool-first approach fails. If a firm adopts the agent workspace and asks governance questions later, the agent workspace will shape the answers. Once workflows exist, pressure builds to keep on running them. Once teams depend on them, permissions widen. Once the environment becomes the start of work, switching becomes painful and costly. So convergence means the choice is no longer about experimenting with AI in a safe corner. It's about whether the firm is comfortable letting an execution surface become a work surface, and whether the firm is prepared to govern it like one. The legal market is approaching a decision point, and it's not about whether to use AI, but how to adopt agent systems without creating dependencies and exposures that cannot be undone later. Some firms will treat this as a tool selection problem. They will compare features, run pilots, and choose the most capable option. That approach optimizes for near-term performance, and it often produces fast adoption. It also tends to defer questions about authority, logging, and lock-in until those questions become urgent. Other firms will treat this as a governance problem. They will decide where execution is allowed, what systems can be connected, what approvals are required, and what audit trails are necessary before they scale. They will preserve optionality by keeping workflows portable and by avoiding deep coupling to a single vendor surface until they understand the implications. Over time, the difference will become visible in operational posture. Portable workflows are easier to move, audit, and defend. Coupled workflows are harder to inspect and harder to unwind. When something changes, pricing, access terms, model choice, vendor policy, or a new class of attack, the portable firm adapts. The coupled firm absorbs disruption. None of this requires firms to be slow. It requires them to be deliberate. Execution systems can deliver real value inside of legal work. They can also create exposures that are hard to explain after the fact because the systems will have acted using ordinary permissions in ordinary environments. So what comes next is not a race to adopt. It's a race to design adoption in a way that remains defensible when the environment changes, because these environments will definitely change. The firms that do best will not be the ones that moved first. They will be the ones that can still move later. Claude Cowork is not interesting because it's polished or safe. It's interesting because it shows clearly and uncomfortably what happens when AI stops suggesting and starts executing. The question is not whether Cowork can be useful, it already is, but whether law firms are ready to run execution systems with real authority over client work. Cowork exposes the same trade-off every agentic workspace does. The more capable it becomes, the broader the permissions it needs, and the harder it is to govern. For firms with professional liability, this is not a question of curiosity or experimentation. It's a question of timing and control. Cowork is a preview of where legal workflows are heading. The only open decision is whether firms approach that future deliberately, with boundaries in place, or arrive there accidentally after execution has already moved faster than oversight. If your law firm is evaluating agent platforms and wants to understand the governance requirements before workflows are embedded, you can book a call with me below. You'll find the link in the description. If this was useful, subscribe for more analysis on how agentic AI actually behaves inside legal systems and what that means for firms trying to adopt it responsibly. Thanks for watching, and see you in the next one.